Hello, I am Jaspreet on this side, and I am company secretary by profession. Here we are discussing, we are doing revision of Companies Act 2013, brushing up our memories. Disclaimer is that there is no other intention, and this be used only to brush up knowledge, and not this is not an advice on company law. So we are using the book Sarans by ICAI. I find this graphically very beautiful, and let's proceed. Last we covered private placement, public issue, prospectus, and now here we are doing share capital and debentures. Share capital definition is provided in section 2 subsection 84. Share means a share in the share capital of the company and includes stock. So it is defined as a share in the share capital of the company and it includes stock. Capital of a company is termed as share capital, which is divided into units having a certain face value. Each unit is termed as share. Okay, so share capital is the capital of the company. It is divided into units having face value. Clear? Kinds of share capital. Section 43 provides that there are two kinds of shares which can be further divided. First is equity shares, which we normally see, and next is preference shares who have certain preferential rights. Equity shares are also of two kinds. Number one is equity with voting rights, and number two is with differential rights as to dividend or voting or otherwise. So there can be differential rights as to dividend, there can be differential rights as to voting, or even otherwise is a possibility like combination of both. So equity shares are with voting rights, which are normally we see, usually we see, and then there are equity shares with differential rights, and then there are preferential shares. Preference shares carry preferential right with respect to payment of dividend. It has preferential right with respect to payment of dividend and repayment of capital at the time of winding up. So preference shares carry two rights as as a right, preferential right as to payment of dividend and repayment of capital at the time of winding up. Plus, they also carry voting rights after 2 years of non-entertainment of dividend that we will cover later. Next is voting rights, section 47. Section 47 provides that how are voting rights provided to equity shareholders and preference shareholders in proportion of paid up capital. Now, equity shares. On every resolution passed or placed before the company, equity shares carry voting rights on every resolution placed before the company. And others means we are seeing it from a Nidhi company's perspective, from equity shares having differential rights and normal cases. Others are normal cases. Normally, ideally, usually equity shares carry voting rights in proportion of paid up capital. In proportion of paid up capital. This word is paid up capital. This paid up capital is not divided into preference or equity. Total paid up capital. Nidhi companies in proportion of paid up capital. Clear? Now equity shares having differential rights. So as defined in articles or terms of issue. So whatever is provided in the terms of issue, that will prevail. In case of Nidhi company, it was in proportion of paid up capital, cannot exercise voting rights on poll in excess of 5% of total voting rights of equity shareholders. So any one person cannot exercise more than 5% of total voting rights. Clear? This is specific to Nidhi companies because Nidhi companies are formed with the uh, means it's like a society for a community for mutual benefit. It's a mutual benefit organization. So each member cannot exercise more than 5% of total voting rights. Next we see preference shares. So preference shares in proportion of paid up capital. Ideally preference shares is in proportion of paid up capital. Then carries preferential right with respect to payment of dividend and repayment of capital at time of winding up. So it carries preferential right with respect to payment of dividend and repayment of capital at the time of winding up. We know this. Now, next is directly affecting interest. Number one, what happens is, what we are seeing is that preference shares carry voting right. Ideally, they carry preferential right as to payment of dividend and winding up. Now, what happens is, if there are resolutions, only those resolutions which directly affect interest of preference shareholders. So if there are resolutions which directly affect interest of preference shareholders, then they have the right to exercise their voting power. Number two, dividend not paid for 2 years or more. If a dividend was to be paid but is not paid for more than 2 years, then preference shareholders carry right to vote on all the resolutions presented before the general meeting or before the, like it can be postal ballot, so as presented before the members of the company. And at the time of winding up, for the decision to wind up the company, in that decision also preference shareholders will carry right to vote. Okay, so if dividend is not paid for more than 2 years, directly affecting their interest or at time of winding up. Okay, so these were equity and their voting rights, preference and their voting rights. Next we move to issue of sweat equity shares, section 54. Issue of sweat equity shares, section 54. Now what is the meaning of sweat equity shares? It is given in subsection 88. What is happening here is, there are equity shares. These are issued by the company to whom? These shares are issued to directors or employees of the company. Then they are issued at a discount or for consideration other than cash. Either they are issued at discount or for consideration other than cash. But what is the purpose? Purpose is against the sweat the directors and employees have given to the company. That can be for providing their know-how. They have provided certain know-how against which they are provided shares of the company at discount or for consideration other than cash. Number two is making available rights in the nature of intellectual property rights or value additions. They have done some value addition. They have made available certain intellectual property rights against which these shares are allotted at discount or for consideration other than cash. So sweat equity shares are given by company to its directors or employees for providing know-how or intellectual property rights or any value addition. Section 53. Section 53 provides that except the issue of sweat equity shares under Section 54, a company cannot issue shares at discount. So if standard question is, can a company issue shares at a discount? Answer is no. However, exception is that sweat equity shares can be issued to directors or employees of the company at a discount or for consideration other than cash against providing their sweat, means against providing their know-how, intellectual property rights or any value addition. Conditions for issue of sweat equity shares. What are the conditions which needs to be fulfilled for issue of sweat equity shares under section 54 subsection 1? Company may issue sweat equity shares of that class which are already issued. So means it is issued only of a class which are already issued, means no new class will be introduced, no preferential shares will be issued, No equity shares with differential rights will be issued unless they are already existing, unless those shares or similar class of shares are already issued to someone else. Issue is authorized by a special resolution passed by the company. Issue is authorized by a special resolution. Special resolution is passed. In case of company whose shares are not listed. Now, a company which is not listed, SR authorizing the issue is valid for making the allotment within a period of not more than 12 months from the date of passing of SR, special resolution. So company whose shares are not listed, they can authorize a special resolution, and that resolution will remain valid for a period of 12 months from the date of passing of the special resolution. Next is resolution to specify the details regarding. Resolution should contain following details mandatorily. Number of shares being issued, current market price at which shares are being issued, consideration if any, means if they are being issued at discount, or if they are being issued for consideration other than cash, then what is the consideration. Class or classes of directors or employees to whom such equity shares are to be issued, means not to any one director, not to any one employee, but there must be a class, a specific class. What is meaning of class? It means that suppose a director resigns, but to that class of director or employee resigned, but to that class of employee, the resolution is already passed and it is valid for 12 months, then even a new employee or new director, if it is falling in that class, the sweat equity shares can be issued against their sweat, means against their value addition, against bringing intellectual property rights. Issue of sweat equity shares must be accordance with regulations and rules. Okay, so this issue must comply with provided regulations and rules. When shares are listed on recognized stock exchange by SEBI. Now, in case shares are listed in a recognized stock exchange, then it will be issued in compliance with regulations by SEBI. Other than above rule 8, above is rule 8, then regulations as provided by SEBI need also to be complied with. Okay, next we move to rule 8. What is rule 8 under Companies Act, companies rules? Rule 8 provide applicability. Then whom this is applicable? A company other than a listed company which is not required to comply with SEBI regulations on sweat equity shares. So other than listed company, this rule 8 is applicable on all companies other than listed companies. Number 2 is limit on issue of sweat equity shares. Can any n number of shares can be issued at discount. So limit is during a year the maximum amount or limit for which sweat equity shares can be issued is higher of, either it is higher of 15% of existing paid up equity capital, or shares of the issue value of rupees 5 crores. This is higher. So the maximum amount is higher of these two limits. Okay, during a year. Time is, one is limitation by time, that is during a year, and number 2 is maximum amount. I mean one is that during a year maximum amount or limit for which sweat equity shares can be issued is higher of 15% of existing paid up share capital, and this is equity share capital only. 15% of existing paid up equity share capital only that can be issued sweat equity shares, so only equity capital is considered, or and we are seeing higher of this. So if 15% is higher than value being rupees 5 crores, then 15% will be considered, or shares of the issue value of 5 crores. What I am understanding is that if the value is up to rupees 5 crores, then that can be issued. However, if 15% of existing paid up capital is higher than 5 crores, then that will become the limit up to which equity shares can be issued. Then the issuance of sweat equity shares cumulative, including all previous issues, if any. So issuance of equity shares cumulative, including all previous issues, if any, shall not exceed 25% of the paid up equity capital. Now this is another condition I considered during the year, but it is not. The another condition is that maximum limit. One is value is 5 crores, other is 15% of equity share capital, paid up equity share capital, if that goes above 5 crores, but still it cannot exceed 25% of paid up equity capital. So it cannot exceed 25% of paid up equity capital. For startup companies, 50% of paid up capital up to 10 years from the date of its incorporation or registration. Startup company means which is registered as a startup. Then it can exceed 25% limit and have a limit up to 50% of paid up capital. Okay, not equity. Paid up capital up to 10 years from the date of its incorporation or registration. 10 years from date of its incorporation or registration. Lock-in period. Do the shares have a lock-in period? Lock-in or non-transferability for a period of 3 years from the date of allotment. So when the shares are allotted, then for 3 years these will not be allowed to be transferred or sold. There is a lock-in non-transferability clause that for 3 years from the date of allotment, these shares will have to be held by director or employee, or more specifically to that class of director or to that class of employee. Disclosure in the director's report. This be also disclosed in the director's report. The board of directors shall inter alia, among other things, the board of directors among other things shall disclose in the director's report for the year in which such shares are issued, the specified details of the issue of sweat equity shares. Then valuation of sweat equity shares. How are these valued? Sweat equity shares to be issued shall be valued at a price determined by a registered valuer as a fair price, giving justification for such valuation. So we have a registered valuer who will determine the price, and that price will be fair price, giving justification for such valuation. So at a fair price determined by a registered valuer. This is the requirement of valuation in case of sweat equity shares. So these are provided in Rule 8 relating to it is applicable to list other than listed companies, all companies other than listed companies. There is a limit that either a value can be 5 crores or 15% of existing paid up equity capital or 25% of paid up equity capital. And for startup, this 25% is 50% of paid up capital, but up to 10 years from the date of incorporation. Lock-in requirement is there up to 3 years. Director's report. In director's report, a disclosure has to be made of the details required to be disclosed in director's report, and valuation of sweat equity shares is to be done by a registered valuer, and those will be done issued at fair price. A fair price will be determined by a registered valuer. Punishment for personation of shareholder means if a person claims to be a shareholder when actually he is not a shareholder. That happens frequently. RTA face that concern frequently because if a shareholder is dead, if in the list of shareholders someone is not claiming dividend, not doing any activity, then someone can personate and try to claim those shares, benefit from those shares. So what is the punishment for personation of shareholder? It is given in Section 57. If any person deceitfully personates as an owner of any security or interest in the company, okay, he is deceitfully personating that he is owner of shares or he has interest in the company, or as an owner of any share warrant or coupon issued in pursuance of this section. So he has interest in any share warrant, okay, or coupon issued in pursuance of this act. He does this deceitfully. And next what happens is, and thereby obtains or attempts to obtain any such security or interest or any such share warrant or coupon, or receives or attempts to receive any money due to any such shareholder. So any money is due to any original shareholder that he tries to get, any share warrant is due to any original owner that he tries to get, any security is due, any coupon is due, any interest is due, which he tries to get by deceitfully personating to be that shareholder. He has attempted this. Even attempting this is enough. Actually, these were transferred or not is not important. Attempt was made and it is found out. He is caught. Then he is punishable. Such person shall be punishable with imprisonment 1 to 3 years or fine 1 to 5 lakhs. So imprisonment can happen ranging from 1 year to 3 years, and fine can happen ranging from rupees 1 lakh, and this can go up to rupees 5 lakh. Minimum fine is 1 lakh, minimum imprisonment is 1 year. So this minimum is given, so this is something a matter of concern. Personation should be avoided. Refusal of registration and appeal against refusal. Section 58. Now, if a person tries to register, transfer shares, and the transfer is rejected, then what happens? Where it is allowed, where is it not allowed? It contains the procedure which needs to be followed by a company while refusing to register transfer of securities. It also contains process of filing appeal against such refusal. So there is a process which a company has to follow if it wants to refuse to register transfer of shares, and in such a case shareholder also has an option to appeal against such refusal. Refusal to transfer of shares or transmission of the right to any security or interest of a member. Now what is being refused? Either the transfer of shares is being refused. Number two, either transmission of a right to any securities or interest of a member is refused. Okay. So in this case, transmission happens in case of death of a shareholder. Private company. Private company will do what? What will the private company do? Send notice of refusal with reason. This notice of refusal is to be sent by a private company along with reason within 30 days from the date of the instrument of transfer or the intimation of such transmission delivered to the company. So this has to be done within 30 days from the date of the instrument of transfer delivered to the company. When the company has received the instrument of transfer, then within 30 days company can send a notice to refuse along with reason why transfer or transmission is being refused. Next is appeal to tribunal. Notice served in 30 days. No notice in 60 days. Okay. Now, what is the meaning here is that appeal can be filed if suppose uh, uh, let's go by the sequence. A notice is, company has sent notice to the shareholder that shares cannot be transferred or transmitted due to the provided reasons. Now, if notice is served, notice has to be served in 30 days. Then 30 days time is given to the shareholder that it can go to tribunal to appeal this matter before the tribunal. In case no notice is served, means company has neither transferred or transmitted the shares, company has nor sent any notice of refusal along with reason, then in this case, after 60 days of delivery of such instrument of for transfer or intimation of transmission to the company, then after 60 days appeal can be filed before the tribunal. What happens in case of public company? Now private company can restrict, has to restrict transferability of shares. But in case of public company can't refuse without sufficient cause. There must be a valid sufficient cause, otherwise public company cannot refuse to transfer or transmit the shares. Public company may refuse to register the transfer within 30 days from the date of the instrument of transfer or intimation of transmission delivered to the company. However, due to sufficient cause it can do, it needs to be careful, and again it needs to refuse within 30 days. Appeal to tribunal. Now, in this case, in case of public company, this timeline, that earlier timeline was that if company has refused, then within 30 days you can appeal to tribunal. But here you have 60 days time to appeal to tribunal, and if company has neither transferred, transmitted nor reverted, and it's a public company, then you have 90 days time to appeal to tribunal. Tribunal will either dismiss appeal or order the following. So tribunal can either dismiss the appeal, or it will order, what will it order? It will order transfer or transmission to be registered by the company within 10 days of the receipt of order. So it can order that within next 10 days register this transfer or transmission of shares. Number 2, rectification of register, and also direct the company to pay damages if any. So if tribunal finds that the register of members is incorrect, then it will ask the company, it will order the company to rectify its register and direct the company to pay damages caused to the shareholder. In case of contravention of order, if the company refuses to comply with the order, means neither, means if it was ordered to register the transfer transmission and it has not done within 10 days, or the tribunal suggested to rectify the register of members and that is also not done, and the damages were suggested to be paid to the shareholder and that is also not done. In case of contravention of order, fine and imprisonment are provided. Section 59 comes into picture. Section 59 entrusts right to appeal with aggrieved person apart from vesting power in tribunal to order for rectification of register of members. Section 59 entrusts right to appeal with aggrieved person, means aggrieved person has right to appeal. It is provided in section 59. Apart from vesting power in tribunal to order for rectification of register of members, means tribunal can order for rectification, that is available, and that right to appeal by the aggrieved person is given in section 59. So this we complete transmission, this we complete refusal to register and appeal against refusal. If a company refuses, then what happens? So we have covered this. We have covered sweat equity shares. We have covered personation of shareholder, and we have covered shares definition and voting power. Okay. So next, what we will do is, next we will continue with, next time we will continue with alteration of share capital, power of limited company to alter its share capital, and take this further, issue of bonus shares, issue of preferential allotment rights issue. So those things we will cover in next video. I hope this is of value to you. This is only for revision purpose. Thank you.